Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. to provide landowners valuable information that you need regarding natural gas development here in Pennsylvania. And at the Clark Law Firm, my focus is solely and entirely on landowner representation. I have and continue to represent landowners all across Pennsylvania, all across the entire state for such matters as gas lease negotiations. And I'm going to talk about some gas leasing today. And I think these are very important issues. And I've been doing a lot more gas leases. It's funny, I have a file drawer dedicated to the gas lease clients. And sometimes there's not a lot of files in that drawer, and then sometimes there's quite a few. And I've noticed over the last few months that there's been more and more files filling up that gas lease negotiation drawer. So we're doing a lot more. So I want to talk, that tells me obviously we're seeing a lot more gas leases. I've been talking about them, recently. Talked about the Tioga County offer that we're seeing with Shell out there last week and the last few shows. So if you're checking out today's show and you say, well, geez, I'm in Tioga County and I have an offer, or maybe you're unleased, you want to go back, revisit the shows, you can go to the websites at pagasleaseattorney.com, go to pipelineattorney.com. You can also check us out on iTunes. If you type in All Things Marcellus in the podcast, or actually on iTunes, you just type in All Things Marcellus or Attorney Doug Clark, and you can check out the shows there and listen to them at your leisure. And also, you can go to iTunes. You go type in the podcast section, All Things Marcellus. You can check out the shows there as well. So again, I represent landowners for gas leasing, pipeline agreements. I do believe, and I'll be conservative, have represented landowners in negotiations with well over 40 different pipeline companies all across the state, all across the western side of the state, across the northern part of the state, and of course the northeastern part of the state. So continue to every day, and usually if I'm not on vacation, 7 days a week, but negotiating pipeline agreements on behalf of landowners. And we know, and I know, unfortunately, I see it all the time, people are still signing bad agreements all across the state. And we want to make sure that you're educated and informed, because I've never, ever worked on a pipeline agreement to date that we haven't been able to make better for the landowner. But then also, say that nobody can make this agreement any better. Okay, that you're going to have to go ahead and execute this agreement. Whether it's me or somebody else, you really need to understand, actually, do you have to execute the agreement? Because most times you don't. And actually, you never really have to execute an agreement, because even if there were eminent domain, which is, again, very rare, but does happen, but you need to understand that, well, you still don't need to execute an agreement. Also, if it's a pipeline that's authorized under your oil and gas lease, meaning because you signed an oil and gas lease, the company is able to install a pipeline. Again, be careful, because a lot of times the landman may mislead you into believing that you do have to agree, or they'll just put the line in under the agreement. Be careful, because that statement is made quite often and it's not always true. So even if a pipeline were authorized, under your oil and gas lease, still don't have to sign a pipeline right away agreement in almost all cases, because they'll just go ahead and say, well, we're going to use these lease rights. So you need to understand that. It's very, very important. So because of that, we're always able to make the agreement better for the landowner, put restrictions in there. Many times the compensation increases drastically. Sometimes it doesn't. You got to really understand the situation. Just this past week, had a client where the offer was below $20,000 to start, and it's now at around $150,000. So had that landowner just simply signed that right-of-way agreement, well, they would have got probably around 15 times less than if they actually explored their options and make sure that they took advantage of their situation. And it's not even taking advantage. I mean, that's what the market is. nobody's putting a gun to the head of the company, if they had a head, and said, hey, I want 150,000 or I want 200,000. You say, well, look, if you want to do this, here's what my price is. The company doesn't have to do it, obviously, but if they want to do it bad enough, they'll meet your price. But again, you have to understand your circumstance. And if it's just your first time doing this, and even if it's your 10th time doing this, and as an individual, it's highly unlikely, obviously, but there are so many nuanced situations here, nuance to this process to really understand what you have and what you can do. So it's really important. How often do I say this? Whether it's me or somebody else, you got to make sure that you're getting this information, understanding your circumstances, and taking advantage of the circumstances as much as you can to make sure that you're getting the best market price and the best market terms, language in your agreement. Absolutely critical. Critical. Remember all the people who sign gas leases, $5, $10, $15, $20, $25. Don't do those. Don't make those same mistakes when it comes to the pipeline right-of-way agreements. And frankly, all other agreements. You must get assistance. And I don't want this to be a giant commercial for me, but you must get assistance. Whether it's me or somebody else, please. Every single day, people sign bad agreements. Every single day, people rely on representations made by a gentleman or a lady working for the gas or pipeline company, getting paychecks ultimately based upon their performance and the work that they're doing, ultimately, again, on behalf of a pipeline company or a gas company. So even though their business card may say their land service company, that land service company has a contract with the pipeline company, with the gas company, and they're there to get your signatures. They're there to get your signature. And they'll say all the time, we don't get commission. Well, what happens to people who don't perform their job or don't perform their job well? And you see in landowners who know who they deal with, these land guys or landmen, they rotate like crazy. It is a job where, in my experience, if you're not performing, it's a hard job to keep. So, here's the other thing. There's also been a big move where I can't tell you how many times, and this is like it started back up again, where these guys, the landmen are, it's almost, I have clients who say that they just feel that they're harassed, where, they show up. I had a guy in New Jersey, they show up in his door. He said, look, I live like 4 hours away. And the landman showed up at my door and said, hey, yeah, I was in the neighborhood. And that's what he said to me. I said, oh my heavens, it's crazy. So, look, they're coming, they're pressuring you. Don't be pressured. Get assistance. And if it's that darned important, then maybe you have some leverage that you're not aware of. So please make sure you're getting assistance. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 a.m. Again, I say I'm doing gas leases, pipeline agreements, well pad agreements, royalty issues. A lot of issues coming up regarding unitization. Are you getting credit for the proper acres? And you got to look at your situation. Sometimes we do these evaluations, say, hey, you know what? There's a problem here. And then other times they say, hey, landowner, unfortunately, I don't see a problem here. But if you feel you have a situation and you feel that it warrants a detailed review, we do those. And a lot of times we find that there are issues. But again, a lot of times there aren't issues. Also doing more and more estate planning, gas lease amendments and modifications, something I do quite often, where company comes to the landowner, says, we'd like to amend or modify or change the terms of your existing lease. Another thing I'm doing more of, especially in Tioga County, company says to the landowner, hey, we would like to do what's called a top lease. I talked about that recently in other shows, where they want to come in and put a lease or lease you even though you have an existing lease. And that's called a top lease that would take effect if your existing lease expires. Another thing, been consulted on these consent to assign of your lease, where company says, hey, we want to sell or assign your gas lease to another company, not the company that currently holds your lease, but some other company. And you may have a lease agreement that says you have to provide consent. Usually that says consent cannot be unreasonably withheld. So in most cases, it's going to make sense that you consent, but not always. So doing some of that as well. And of course, surface use agreements. I don't care if it's a roadway agreement, if it's a staging area agreement, if it's a water withdrawal agreement, if it's a well site agreement, you need to be protecting yourself. You need to be maximizing compensation. You need to make sure that by signing this other document, you're not losing your indemnification or liability protection that you may already have under your lease. You have to understand how these documents are going to work together. Now, at the same time, believe me, very mindful, we don't want to generate work or manufacture work or get you bills that you don't need to have, because you don't need to have this intense negotiation regarding this particular agreement. You need to make sure that you have at least your bare bones coverage, because it's something maybe this is authorized under your gas lease. So there's always something to do. Sometimes it's much more involved, sometimes much less involved. But as I've said on the show before, usually if there is more time and more effort that's involved in this process from the attorney's perspective, well, and a lot of times what that means is there's additional compensation that's going to be given to you as part of this process, because you're negotiating the financial aspects. But then also, if more time is needed, that's telling you, boy, that document was problematic. So all of those things come into play that you got to understand what you have. All right, again, I don't like to do this big commercial, but it is my intro section. So if you do need any representation, have any questions, you can always contact me at 570-307-0702. Again, Doug Clark, 570-307-0702. And want to also remind you, I talked about this, and I do promise, it is a-coming. Working on the websites, pagasleaseattorney.com. We're going to be revealing or going live with the new websites here, certainly, hopefully, by the end of the year. It's funny. I'm working with my new web guy, and I have to do, this weekend I've been spending a lot of time writing content. And so we're in this process of working together. He says, we need more, we need that content. We need that content. And I said, well, what does content exactly mean that you need from me? And I've learned that content is kind of lingo for words, meaning we need you to write some more words and send them out to me. So what I'm doing is I'm redesigning the sites. I'm also adding some sections. I'm updating some of the language that's in there. I'm writing content, aka writing words, and adding some different tabs and things like that. So we want to make sure that we're getting more up to date, more information out to people. We're going to have the radio shows all up on the pagasleaseattorney.com site, dating back to August of 2010. So you can check those out there. It's going to have a new look. Really, really excited about it. It's coming along really well, and it's something that I'm working on as much as I can, and I think everyone's really going to enjoy it. So you can check out pagasleaseattorney.com now if you haven't, and then you'll be able to check it out again here in the next few weeks and see what we've done and the changes that we've made. So, okay, what I'm going to talk about here today is I'm going to talk about a gas leasing situation. I'm going to talk about some terms and provisions, and this is going to give you guys an idea, just the things that you should be thinking about, the ideas of, hey, what's going on out there? Maybe this doesn't apply to you each section, maybe some sections do, but it gives you the information and knowledge of, hey, these type of things are going on out there, and whether I have these same terms and conditions or same concerns, maybe I don't have identical concerns, but this is giving me a little bit of heads up that I need to be looking out for things. I'm going to go through this and give you some examples. I think this is going to be pretty interesting. All right, when we get back, I will go through a lease example and some language and some ideas. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I was talking in that first segment a lot about representation that I do for landowners. And one thing I want to touch on too, I said I've been doing a lot more leasing, so I've been doing some more shows on leasing. What I try to do when I start seeing some of these issues or we start getting more calls on a certain topic, then I try to go ahead and steer the radio show towards that topic. And one of the things that I've been getting a lot of calls on recently have been leasing files. And I have a lot more clients with leasing, and not just in Tioga County, which getting a lot of calls from there, but also Susquehanna and other counties as well. So we're going to talk about leasing today, but the other thing that's been occurring a lot had probably at least 5 calls this week. And we get these a lot, but this seems to be a rush over the last week or two where landowners are calling because they have offers to buy their oil and gas mineral rights, and they get these letters in the mail. If you're a regular listener, you know I talk about this quite often, and I've done a lot of shows on this topic. I'll probably do another show or two on the topic as we go forward, and maybe more, who knows. But I want to make sure that everyone realizes that if you get these letters and you think that you may want to sell your oil and gas rights, and say you love the offer and you want to do it. One gentleman says, hey, look, I'm older. I sell my oil and gas rights. I'm out of here. I'm going down to Florida. I'm going to retire. I'm going to be really happy. I don't know how long it's going to take to develop this property, if it ever will happen. And when this company pays me this money to buy my oil and gas rights, well, that's going to put me in a position where I can retire, put this behind me, and go ahead and move on. And you know what? Can't really argue with that in this case. He has no heirs, no beneficiaries. He says, hey, you know what? This is the right thing for me. And if you explore all of those different things and you say, you know what, this is right for me, this does make sense for me, then okay, maybe it does and you should go ahead and do it. But let me caution a couple things. Number one, you need to be asking yourself all of the right questions when you're doing this evaluation process. You may think that this is the right move for you, but you need to make sure that you're asking yourself the right questions, that you're considering everything that you should be considering when you're engaged in this evaluation process. And my experience has been in talking to landowners that maybe there's some things that they weren't thinking about. So you want to make sure that you're asking yourself all of the right questions. And when you do that, then, hey, again, maybe this is the right move for you. Now, that's step one. Step two is you go ahead and you decide, yes, this is what I want to do. This is definitely what I want to do, and I'm going to go ahead and do it. Now we have to turn to the actual offer and the documents. You get a sales agreement. Well, what does that sales agreement say? And my experience has been they are very, very one-sided, and they don't need to be that one-sided. There's no reason that they should be. So those documents, every one of them we've changed, or I've worked on that we've changed because they need to be changed. You have to look at, well, what can come up in the future, and you want to make sure that you're not giving away more rights than what you want to or what you plan to. You want to be looking at the value of your property. You want to be looking at, what can occur in the future. What are you doing to the surface of this property? What does your original lease say? So then you got to go and turn and you look at those documents. You don't want to give, if you're just selling your oil, gas, and mineral rights, you don't want to give more rights away. You don't want to give additional surface rights that you don't have to give away. You want to give away what you understand that you're giving away. And a lot of times, my experience has been that these documents, actually, I don't want to say a lot of times, every single time, the sales agreement goes beyond, I believe, what it needs to, and we always adjust those documents. And a conversation with somebody who is experienced and understands this is going to shed a lot of light on this. And I've talked to people who thought that, or who made the decision, you know what, I think I'm going to go ahead and I want to do this. And then we go back and we look at the documents and they change their mind. They say, wow, I didn't realize that. There's things in there, a lot of times it'll say, I want to make this show about this, but I'm going to just say this. Watch, because you may enter into a sales agreement that says, as of January 1st, these rights are being transferred, even though we may not close on this deal for several months later. Well, if royalties start, well, you're giving up those royalties as of that effective date. So you need to be aware of that. And I've seen that happen. And thankfully, talking to a landowner, I said, wow, I didn't realize that. I thought I would continue to get the royalties up till the time of this actual deed transfer. But no, that sale effective date, as everything went through, would have been the date that this are indicated on the sales agreement. So you got to be careful. So if you're considering selling your oil and gas rights, you can contact me. I do sometimes will do these consultations. Again, I apologize because it's maybe it's more commercial than I like, but I hate to see people. First, in my experience, I don't think it makes a lot of sense to sell gas rights in most cases. However, I do agree that sometimes it does. But if you're considering it, you need to make sure you're looking at everything the right way. And I do consultations, and then we do representation, because if you're going to do it and it is the right thing for you to do, we need to make sure you're doing it right. So you can always contact me at 570-307-0702, 570-307-0702. I'm doing this. I'm getting a little commercial because I don't want to see people just saying, yeah, I like that price. This all sounds good. Let me go ahead and sign this document and I'm all set to go. Please, we got to be careful. You got to be careful. I am Attorney Doug Clark. You're listening to All Things Marcellus. I am here every Sunday from 8 to 9 a.m. And finally, transferring over, I'm going to talk about some gas leasing issues. My point here with this is I'm going to talk about some general things, some specific things, but the idea is if you're out there and there's a lot more leasing going on, and this no matter where you are in the state, these are some things to be thinking about, looking at, and also saying, okay, here's examples where I may not understand something, or I may think I have some benefit, and the reality is that maybe I'm confused, or I'm maybe being misled, or I haven't fully understood the offer that's being presented to me. So I'm going to I'm going to mix and match and take some language from different agreements and things that I've seen. In a lease agreement, a pipeline agreement, any agreement, you usually have what we call the granting clause, where you, as the landowner, are granting rights to a company. In exchange for that, well, the company's going to give you money, and then they're going to give you different terms and other benefits. So you need to fully understand what you are granting or giving to the company in exchange for this money you're receiving. Money is great. We look at the money, but we want to also understand, well, what it's in exchange. They're not just handing you money for fun. You're giving them some kind of rights, and we would like to limit those rights as much as possible. Can't always limit them how we would like to, but you want to limit them, and understand, though, with this money comes some cost. What can we do to get as much money as we can for you as the landowner, and also reserve as many rights to you as the landowner? And that's obviously a foundation of this process. All right, so in this example, in this particular lease, not all leases are created the same. So some granting clauses are much more broad than others. Most granting clauses, though, are very broad. So we look at, well, where do we see some differences? And one of the areas, and I'm going to read from this agreement, but one of the areas that we look at is, are you giving rights beyond gas that's going to be produced from your particular property? Meaning, you would think when you're entering into a gas lease that lease is going to say, okay, company, you can extract gas from my property. In exchange, I would receive royalty benefits. Pretty simple. But then you also turn to, okay, well, let's think about this. How, company, are you going to extract the gas? Well, they may have to drill on your property. Well, what does that mean? Well, they'd have to construct a well pad. They would have to have a drilling rig out there. They would be fracking the wells. They would need a roadway or an access road to get to the pad. All common sense. We got to make sure you're thinking about these. And know that this pad and this roadway area can take many acres. 10 acres, 15. I have a couple clients that I've dealt with or represented over 20 acre well pad with the roadways. So that's a very big area. and some are smaller, but you need to understand those things as well. Well, all right, hey, I'm going to get royalties, so this is part of this process. I understand it. I'm getting money to sign the lease. I'm okay. I understand this process. You say, all right, well, now too, remember, there may be pipelines. Well, if they're drilling on your property or on your neighbor's property and they're extracting gas from your property, they're going to need pipelines to get it out. Now, here's where it starts to get more interesting. All of these things are reasonable. Now, can we start having input as to where these activities may occur? Maybe restrict where these activities can occur. Now, that would be nice. We don't want them in our backyard or our front yard. We want to have some input. But can we also restrict to say, hey, I don't want pipelines coming across my property if they're not going to benefit me, if they're not going to be carrying my gas? When you enter into a gas lease, like we just talked about, you're thinking, hey, in exchange for money, I'm going to give them the right to maybe operate on my property with the idea of receiving potentially future royalties. Well, if there's a pipeline that goes across your property and your gas isn't in that pipeline, well, you're not getting royalties from that gas. Also then, what about a roadway? Maybe there's a roadway that's allowed under the lease to go across your property to a well pad somewhere else, and you're not getting royalties from all of the wells or maybe some of the wells on that neighboring or sometimes even distant well pad. So did you give the company the ability when you're signing the lease to put in pipelines that do not transport your gas? Did you give them the ability to put in a roadway across your property that is going to a well pad where wells are going to be drilled, and those wells are not going to generate royalties for you? And that roadway now, maybe you didn't have a good lease and they put it somewhere in your property you don't like. That's going to be there for decades and probably many decades. And you're going to have truck traffic. You're going to have this typically unsightly road somewhere where you may not want it. So that's a bad thing. You're going to get also, I've talked about this because this kills me. You're going to also potentially have clean and green impact. A roadway to a well site would take that property out of clean and green. So now you may have a roadway on your property going to a well pad where you're not receiving royalties from. And now every year, your tax bill, you have that roadway area is taken out of clean and green. And what does that mean? You're paying a higher tax rate. And if you're in a county that charges a commercial tax rate, you're talking about $1,000 to $1,500 per acre per year. And I suspect that other counties are going to start following suit of many counties who are already taxing at that commercial rate. All of these things you need to be aware of. How bad is it? If you think about this, play this scenario out where you entered into a gas lease thinking you were going to get royalties or potentially get royalties, and you said, okay, yeah, they can operate on my property, but that's okay because I know I'll be getting royalties from that. Well, what now if there's a roadway and it ends up being in an area where you absolutely don't want a roadway, taking up a huge portion of your property at times, and you're not benefiting from that roadway in any way, but you're seeing all this traffic going back and forth, which of course will slow over time, but you're seeing all that. That roadway is there. You're not getting any money. Now, you maybe got a couple dollars, $5 a foot. Maybe lucky, got $10 a foot, maybe. But now you're getting a heightened tax bill as a result of this roadway. And now what happens if your lease expires? If your lease expires and you never got any royalties, but you got a roadway or you got a pipeline possibly too. These are things that you have to be guarding against. Thankfully, some companies aren't kind of doing this in a situation where they would be able to do this right at the beginning. But some leases that are presented to landowners, and especially as we get to the western side of the state, and my belief is because in the western part of the state, there's more familiarity with gas development because of the conventional wells, the vertical wells, where landowners were they signed documents much easier. And I think these companies are still taking advantage of that mentality. So I'm going to read this some language here that would give a company more rights than maybe what you think they have in the lease, and things they need to watch out for. Then I'm going to talk about some tricky terms that we see in agreements, and talk about some addendum terms and how you need to make sure that you fully understand them, because you may think you have something and you like the heading that the company presents, the addendum, but then when you read the words, it's not so good. All right, I am Attorney Doug Clark. You're listening to All Things Marcellus. I ran way over on this section. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm here every Sunday from 8 to 9 a.m. You can go back, check out PAGasLeaseAttorney.com, PipelineAttorney.com. A lot of great landowner information there. Landowner information. Check out the sites. Learn some more. As I said, I'm working on developing the new sites or updating them. Well, developing and updating. And I've been writing content, aka words. And we're going to have a lot more information on the sites here. And we have a target date. I always get worried about that. You get a contractor or somebody going to work in the house, or it says, "Oh, we'll have this thing done by June 1st," and it's never done on June 1st. Now, it's not necessarily my web guy's fault in any way. Actually, I'm very excited about the new guys I'm working with, but still have to get this content done. I'm doing it as much as I can, weekends, evenings. Really excited about it. So make sure you visit PAGasLeaseAttorney.com. Check it out now. And you can check it out again here in the next few weeks as we get up here and get the new sites going. Should be up here, I'm going to say by the end of this year. But actually, we have a target of a little bit sooner than that. So anyway, check out PAGasLeaseAttorney.com. Check out PipelineAttorney.com. And again, I'm here every Sunday from 8 to 9 a.m. All right. Want to go back to the gas leasing. What I'm going to do, I'm going to talk about this granting clause here. So I'm not going to read the whole granting clause, but I'm going to get into some language which I have quite a bit of problems with, and language which landowners need to be aware of. Thankfully, not all gas leases contain this language, but leases that contain this language, to me, red flags all over, and we need to counter this language by trying to get addendum terms to eliminate this language. And if you can't do that, the company says no, 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 well then you need to understand that this may occur. So okay, this particular gas lease talks about all of the drilling rights to develop, explore, market, production, your land, adjoining lands, current techniques, future drilling techniques can be used, all of those different items which are common and which make sense. Very, very broad, but understandable. Well, it goes on to say that the company also has the right to use or install roads, electric power, telephone facilities, and to construct pipelines and appurtenant facilities, including data acquisition, compression, and collection facilities for use in the production, transportation, and marketing of products from the leasehold, your property, and pay attention now, and from neighboring lands across the leasehold, and from neighboring lands. Neighboring. What does that mean? Be careful. Also, in this lease document, there's references to adjoining lands, touching lands, neighboring lands. Does that mean adjoining? Well, if a document uses the word adjoining and then in other places uses neighboring, I would think that neighboring is a more broad term. That adjoining, pretty simple. Your property adjoins or touches this other property. Neighboring, that definition is probably a little more broad. You can sit there, growing up where I grew up, we said, yeah, he's our neighbor. Well, their property was nowhere near touching our property, but we considered them neighbors. So neighboring lands is very concerning to me. So again, this agreement gives the company the ability to install roads. Remember what I talked about last segment. Install roads, electric power, telephone facilities, construct pipelines, appurtenance facilities, also collection facilities, compression, transportation, and market the products on the leasehold and neighboring lands across the leasehold. Now, pay attention to this. And such rights shall survive the term of this agreement. Did you hear that? That you're giving up all these rights, and these rights shall survive the term of the agreement. You must understand what that means. Again, please understand, I'm only going through a portion of this document. This is not specific advice for anyone at all. This is only a portion of an oil and gas lease, but this is a very important portion of this lease. When you start seeing language that references the ability to have rights that survive the term of the agreement, you need to be aware of that. You need to understand what that may mean to you. You need to understand, does that mean that there could be a roadway that is going to a neighboring land that will stay there even after my lease terminates? Same thing with the pipeline. Also then, whenever later on, if somebody comes to you, a landman comes to you and says, we have rights under your lease, you need to understand what that means as well. You need to understand, are there limitations to how this works and the survival? What can we do to eliminate this? And possibly we can take care of this by saying something to the effect of, only pipelines on this property are to transport gas produced from units in which your property is located. In other words, that you're going to be generating royalties from those pipelines. Same thing with roadways. Is the roadway going to a well pad, and that well pad includes the unit that you are in? Well, that's generally a pretty reasonable thing. Here's another little nuance, and there are so many of these tricks out there. Company says, oh yeah, we have the ability to put this roadway on your property because it's going to a well pad where you're going to go ahead and benefit because your property is a unit with this well pad that this well pad is going to service. However, a little secret that's out there. So what happens is the company gets you or approaches you and says, hey, we want to sign this roadway agreement to this well pad. And if you didn't do it, we have the right under your lease to put a roadway. Well, maybe they do, maybe they don't. Maybe they have the right to put a roadway to a pad that the wells are servicing your property or you're in that unit. However, what if they're drilling wells off of that pad in other directions into other units? And we're seeing this more and more. Other units that do not include your property. Well, if that's the case, then maybe they don't have the right. So maybe you can say no. Maybe you can say, you know what? You have the right under the gas lease. Go ahead and do it. Go ahead and do it. And I have some of these going on now because some of these gas leases, especially some of the bigger ones, the more complex ones, have a lot of restrictions with how big can the roadway be? What type of material can it be made out of? How is it going to be maintained? All of those things where you need to understand what you have and what the company is asking for. All right, I got off track a little bit there, but very important. So this particular lease, when you're presented with the lease, you need to understand the granting clause. And most people are going to be overwhelmed. It's very broad, and that's expected. But things like terms that are going to survive or rights that are going to survive the termination or the term of your lease, red flags. You need to try to address that, or you need to understand it's there and say, you know what? At the end of the day, at the end of this process, I'm willing to provide those rights based upon the compensation that I'm receiving and the realistic expectation I may have for future royalties. But on the flip side, it could be something that you recognize, and your attorney's a good attorney. He recognizes, she recognizes this. And what does he or she do? she or he gets an addendum or addendum terms that stop this, that take away those rights. So then what happens is when a company comes to put these types of roadways or pipelines, number one, you can say no. Maybe you can totally change where the location is going to be and end up reaching an agreement. Maybe you can get a lot more compensation for it. Maybe you can get more compensation, you can get it moved in a whole different area, or you can, again, simply say, thanks, but no thanks, and just move on. So you need to be looking at those today. So when you get a new gas lease, and especially, and this is everywhere, it's everywhere, but I really get concerned about Western Pennsylvania. I'm from Western Pennsylvania originally, and I see worse leases being handed to people and offered to people in Western Pennsylvania as far as the form lease goes. And I'm convinced that they're doing that because people in Western Pennsylvania are used to kind of signing these documents, and they're just quicker to sign. And that's a concern for me because I want to make sure that landowners are not being fooled, tricked, or taken advantage of. So please, you have to understand it. Take it to somebody who understands it, not someone who just looked at it or is looking at it just because you're an attorney. Take it to somebody who understands what we're looking at. I'm not going to digress too far, but I just reviewed a lease for a landowner, and I had to give this landowner some pretty bad news where I said, you have some really good royalty language as far as what type of deductions for transportation and cost and things of that nature that may be taken. However, I don't think they apply at all to your particular lease because they were never tied in properly to the royalty section of your lease. So although there's language that reads really nice, sounds great, does it actually apply? And unfortunately, I think there was a mistake made because I don't think that the language has all been tied together appropriately. And what's going to happen is when this landowner starts getting royalties, I suspect they're going to be very disappointed because they're going to see deductions being taken when they thought that no deductions would be taken. And not going to continue down this path too far, but remember, I've talked about this recently all the time now. All the time, every single week, I get landowners who call and say, I got this offer and it's free of deductions. And I have to do the old, not so fast, my friend, not so fast. Unfortunately, you need to understand that although that's what you were told, and maybe it does occur that way, but I'll tell you this, there's a good chance it doesn't occur that way. So you have to be careful. Listen, I've done shows on this recently in the last few weeks. You're out there and you're in that position, go visit pagasleaseattorney.com. Go on iTunes, type in All Things Marcellus. Listen to the shows last few weeks talking about these deduction issues, talking about offers where literally the language says that the company is giving to royalties without deductions. And the reality is, I'm not so sure that that's what you're going to ultimately see. You have to understand that. You have to. I represent literally 170 some clients in royalty claims right now. And I can tell you, none of them are happy about the deductions, and nor should they be. So you can't be surprised. You must understand this. And I state again, you may go through this, you may understand it and say, you know what? Look, I understand this. I think this is the best thing for me, and I'm going to go ahead and move forward. And that's a good thing, as long as you understand it. But please don't make decisions not understanding what's in front of you. All right, I am Attorney Doug Clark. I'm going to talk about some addendum terms and some other slick little tricks. Some not so little, but all of them very slick. I'll be right back. You're listening to All Things Marcellus with me, Attorney Doug Clark. I'm here every Sunday from 8 to 9 a.m. and again right after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I'm here every Sunday from 8 to 9 a.m. talking about some gas leasing issues here today. And, I do this to myself, unfortunately. Here I am. I'm looking. I got like a little over 10 minutes here for my final segment. And I got a whole bunch of addendum terms circled that I want to talk about. So what I'm going to probably do, I'm going to talk about some of these, but I'm going to put some on the back burner to talk about in the future because they are very important. But I want to highlight a couple things here which are extremely important. And one of them is I talk some about the royalties and understanding that royalty term. That may be the most important thing to understand. And sometimes the understanding is, well, I understand that it could mean a few different things, and that time will tell how it's ultimately going to be interpreted. And that may be a part of it, or it might be, unfortunately, simpler than that, where you say, well, okay, deductions are going to be taken. Here's what that means. But understanding that royalty term and doing everything you can to maximize how your royalties are going to be calculated to your benefit is critical. Absolutely critical. And in today's market, where the royalty percentages that landowners are receiving aren't what they used to be in almost all cases, well, the other tool that we can use is how do we maximize how your royalties are going to be calculated. Very, very important. Going back to the lease that I was talking about before, or, well, actually, I think this is the same exact lease, talks about the royalties. Just to give you an idea, and sometimes I say, even if it's bad, but it's clear, at least it's clear. At least you know what you're getting. And this document, the actual royalty term talks about to pay the landowner royalty less those taxes, assessments, and adjustments, and other deductions on production as permitted or allowed by law, rule, or regulation. Look, they're not hiding it. Give them credit for that. They're saying, we're going to give you, and it's a 12.5%, 1/8 minimum royalty. They're saying, landowner, you sign this, we are going to take every single deduction that we can legally take. Taxes, we're going to take transportation, gathering, compression. We are going to give you the guaranteed minimum royalty of 12.5% in Pennsylvania. But we're telling you right here, that's all we're giving you. And we're going to do everything we can to deduct every charge that is legal. They're saying, look, we're not going to break the law, but we're going to use every tool at our disposal to make every deduction that we possibly can, and we're going to pay you your guaranteed minimum royalty. At least they're clear, but what can we do to improve that? Maybe it's nothing, but if it is, we need to understand that. We need to have worked at it, because if you are able to change it, and it's all relative to acres and air area and all these other different factors and the cost of the transportation and the gathering, but it can be hundreds of thousands of dollars. It can be tens of thousands. It could be hundreds of dollars. But it could be something that by knowing what to ask for, by knowing how to phrase it, maybe some technique in this process, that you can change the royalty calculation method. And if you're getting, we have it, and I could throw all kinds of numbers out there. We have 174 clients. I look at royalty checks all the time. So you take a landowner, there are landowners out there, and some have many more than this, but you say it's $1,000 a month in deductions. If you were able to stop that, if you were able to get the company to agree to language, and that language worked, important part, then right there is $12,000 a year. And, take that out 10 years, 20 years, 120,000, $250,000. Those are real numbers. Sometimes they're higher, sometimes they're lower, but they're real numbers. And many people in Pennsylvania have signed leases that had they known to ask, had they just known to ask, they could have had a totally different royalty calculation provision, which could have resulted or would have resulted in them receiving tens of thousands and sometimes hundreds of thousands of more dollars. But they didn't ask. And surprisingly, that landman who was so nice, that landman who just happened to be in your neighborhood in Philadelphia or New Jersey or Pittsburgh or New York, wherever you were, he or she didn't tell you about that. Yeah, they didn't tell you about that because why? They don't work for you. They work for the company. I am Attorney Doug Clark. You're listening to All Things Marcellus here every Sunday from 8 to 9 a.m. So please understand the importance of that. And whether it's me or somebody else, please make sure you're getting this assistance for yourself, for your children, your grandchildren. Make sure you're getting this assistance. It's your property. You need to make the best of your situation because we know the company is going to make the best of their situation every single time. And every time they put their arm around you, that should be another flag that, hey, look, they're not your friends. You're engaged in a very serious legal contract and negotiation, and you need to make sure that you're doing everything you can to protect yourself. This isn't it's not some battle necessarily. It can be done, and we do it very professionally and cordially, but it has to be done. And if you can't get certain things, you need to understand you can't get them. You need to understand what that means, and then you need to make your decision based upon all of this information. All right, another thing I want to talk about in this particular agreement as well. And again, I'm going to talk about some of these other addendum terms. I could do another hour right now, but something else I want to talk about. Arbitration clauses. Number one, you need to have a discussion with your attorney to say, do you want an arbitration clause? Do you have to have an arbitration clause? How is that arbitration clause going to work? We're seeing how these arbitration clauses are playing out, and we want to make sure that you're doing everything you can to create the best situation for yourself moving forward in the event there is a problem or dispute. Everyone goes into these contracts thinking we're not going to have a dispute. And I'm not going to be in court. I'm not going to be in arbitration. Most people never have been, and most never will be. However, we're seeing many times where, because of the way the company is interpreting a contract, a landowner may have feel that they have little or no choice but to go ahead and pursue a claim. Not that you want to, but you may have to because of the amount of money at stake and the terminology of your agreement. Please, please, please watch out for terms like this. And I haven't seen anyone forced to have to agree to a term like this. But in this case, there's an arbitration provision. Without getting into all the terms, an arbitration is an alternative to court where typically each side selects an arbitrator who's an attorney or maybe a judge, retired judge, and then either those two arbitrators pick a third or the parties agree on a third, which they call the neutral arbitrator. But remember, you're picking one, the company's picking one. The company has a lot of money. They're probably going to pick a very good and expensive arbitrator because they want to have somebody with some power, carrying some weight into these proceedings. And there's a good chance you as an individual may not have the ability to select somebody of that equal weight and power. Now, the concern that I have here, and I've talked about this before, but please, these are agreements that people are getting right now. This arbitration clause in the actual agreement, and I mean in the lease itself, says that the award shall be, so the award of the arbitration panel, the three people that are selected, the award shall be unanimous, by unanimous decision of the arbitrators, and shall be final. Well, think about that. What's the chances that the company appointed arbitrator, company appointed, you appoint one, they appoint one, the third is supposedly and hopefully and should be neutral, you're coming into a royalty dispute as to what is the definition of this marketability, say, and what is royalties, royalty calculation, can deductions be taken? And there's arguments on both sides. There are arguments on both sides for certain. Well, reasonable people can disagree. There are not just one Supreme Court justice in the United States. So why, and we get 5-4, we get these different decisions. Well, if you have three arbitrators, one appointed by the company, one that you appoint, And then in neutral, what is the chance on a disputed issue where there are reasonable arguments on both sides that the company arbitrator is going to rule in your favor? Very, very little, in my opinion. So please do not agree to unanimous arbitration provisions. They can be extremely costly down the road. Okay, I'm up against it. You're listening to All Things Marcellus with me, Attorney Doug Clark. Join me next Sunday from 8 to 9 a.m. and have a great week, everyone.